Please be seated. Third case on our docket this morning is 22-50203, Galaviz versus Reyes. This is Manzur.
Good morning, and may it please the court. My name is Maria Vallejo on behalf of Abigail Gramillo Galaviz, the mother of the two young children at issue in this case. We're asking this court to reverse the district court ruling and hold that the children should be returned to Mexico, the place where they lived their entire lives. In the simplest of terms, this is not a case about who should have custody, but where should the decision be made. The courts in Mexico are perfectly capable of handling this typical custody dispute, and the Hague Convention gives them the right to do so. There's no record evidence of urgency or gravity that should jeopardize Mexico's clear primacy here. As a matter of fact, Mr. Reyes himself recognized the authority and the competency of the Mexican courts in Juarez as he filed a suit for visitation and access shortly after the separation. It's worth noting that he did not allege abuse or neglect at that time or during the whole year his suit was pending. And instead of complying with the social studies and the psychological evaluations as required by Mexican law, he did nothing. And he did nothing for so long that his suit was dismissed for want of prosecution. 3 months after his suit expired, he decided to retain the children in El Paso, Texas, and it was only then that for the first time, he made these thin, unsubstantiated allegations of abuse involving a phone sleeper and some anonymous text messages. This is what we learned from this court in Soto and England, that the Hague Convention was designed to protect against international parental kidnappings with the purpose of foreign shopping. And as we learned from the Supreme Court in Abbott and most recently in Monaski, the Convention's core premise, its central operating feature, is that the interests of the children are best served when their home country gets to make their custody decisions. The whole Hague Convention and its effectiveness relies on this spirit of mutual trust and cooperation. And it's because of this core premise that when a court, a federal court, presides over these cases, they're required to presume that the courts in the home country can fairly adjudicate the custody dispute and protect the children if necessary. And this presumption is so strong that a parent resisting the return of the children has to prove by clear and convincing evidence that one of these extremely narrow defenses apply. But this is not what happened here. Here, the factual record and the court's legal conclusions dramatically depart the long-standing, well-established Hague jurisprudence. And if allowed to stand, it will render the convention effectively meaningless. Indeed, it would not only allow, but frankly, invite parents to kidnap their children and make their way to our federal courts.
So if you had a case of strong evidence of extreme physical and sexual abuse, would you agree that we would not apply the Hague Convention in that situation?
That's the case, and that has been the case in many of our.
So the problem here then is that's what the district court more or less found here, right? And correct. So I obviously understand that you and your client vociferously disagree with that, but it is a factual finding from a district court that we traditionally defer to.
That's correct.
Why do we not defer here?
Well, Your Honor, as Judge Richman explained in Gunnerman, you owe deference to the court's factual findings when they're supported by substantial evidence. And this is not the case here. But the central issue, Your Honor.
Well, I thought there was testimony as well as these admittedly anonymous reports, but there's also testimony, right?
Yes, the anonymous report.
The testimony other than by the parent, other than by the opposing client.
Could you specify which testimony are you?
Wasn't there testimony from a friend?
That's correct. So just to put things into perspective, that friend was only able to give example of one simple instance where Ms. Gramillo disciplined her son with a foam slipper. There's no testimony about injury to the child. That's the worst example they could come up with. That doesn't even pass
I thought there was also testimony, tell me if I'm wrong, maybe I'm mistaken about the record. I thought there was also testimony about the mother hitting the children anytime they would cry. Is that
Your Honor, this testimony was so vague and so
so vague?
Yes, vague, generic, broad. So when courts are looking at,
When you say vague, you mean there was no specifics about
there were
what day it happened or what happened?
What happened if the child was
But you acknowledge there is that testimony in the record.
There's
Not just the foam slipper, but also these other incidents.
Correct. So there's testimony of her saying that she will hit the children because she was frustrated with him, and the one about the foam slipper. None of them talk about injury to the child in any way. That wouldn't even pass the Texas Family Code test for child abuse. There's no testimony about that at all. And in fact,
I'm sorry, there's no testimony or the testimony is vague?
the testimony is vague, but there's no testimony about injury to the child, certainly no substantial injury. So let's look at the other cases that the court cited in its opinion. If you look at the other cases, you see how this case falls short. And if we allow this case to stand, if we agree with the conclusions, it will wreak havoc on the precedent under this circuit. It will turn it on its head because the federal courts will become the forum of choice for custody disputes. The level of harm alleged in this case, that we, of course, contend that is not substantiated by the record, is not the level of harm of the cases cited by the own court. In Walsh, the court said that the violence of the parent knew no bounds, that their attacks were bloody and severe, that the father attacked the mother in the presence of the children. The children were spanked, were spit on their face, were locked in their rooms. And we had very strong expert testimony in that case, saying that the children were experiencing PTSD. That's the same with Simcox, which is another of the cases that the court cites. But we don't have that here. And as far as you mentioned the anonymous text messages, the contents of those text messages were admitted against the judge's own instructions. They were inadmissible. They say that it was only going to be admitted for the purpose of showing that he had received the text messages and the police reports were made. These text messages, anonymous text messages without a date, were received almost 20 days after he retained the children. And we have no SANE examination. We have no outcry of a child, no psychological evaluation. CPS, the agency responsible in this state or in Texas for investigating claims of abuse or neglect, closed the investigation with no findings. This is not it. The case falls short. And although we all do deference to the court's factual findings, the central issue here is whether the defense can overcome the strong presumption for return. So then the court should, and that should be reviewed de novo, because that's a conclusion of law. So then the court can and arguably should review the record to see if Mr. Reyes was able to prove by clear and convincing evidence that there was a grave risk of harm. That is not the case here. And as far as allegations of medical neglect, they're even weaker. The record is replete with documentary, uncontested evidence showing that she was taking the children to the doctor and she was taking them to specialists. The court's own findings don't support its conclusions. The court talks about the children were receiving some vaccines here and then received others in the US. The children were receiving some treatment, dental treatment here, and they received other in the United States. They were kind of lukewarm, but it's on the conclusions in law that the judge makes these conclusions, these inferences that are not supported by substantial evidence. Again, we have no testimony about the severity of the harm, about the nature of the abuse. We have no testimony of the likelihood of recurrence. We have no testimony about the injury to the child, the extent of the harm, or probability of harm upon return. This is, the allegations of Mr. Reyes are akin of the ones of the custody dispute. That the convention asks us to trust, and the Supreme Court recognized in Abbott, to have no doubt about the other country's ability to make a best interest determination for the children. This is not the case. This court in Soto say that grave risk findings are rare. And they're so rare that this court has never affirmed a grave risk finding that will overcome that strong presumption of return. This case shouldn't be the first. If this case stands, Soto would no longer be good law. Many of the rulings from lower courts will no longer be good law because courts hold to such a high standard, this heightened evidentiary record of clear and convincing evidence of proving grave risk of harm. And although there's no definition of grave risk in the convention or in the...
I recognize that a lot of cases you cite, they involve a lot
Correct.
more extreme fact patterns. I grant you that completely. What is your best case for the principle that a lesser evidentiary finding is not enough, which is obviously a different point, right?
Well, Your Honor, you can tell me that circuit and I can give you an example. Let's talk about Chamburus from the First Circuit. There was testimony about that, hitting the child, spanking it, hitting it with a spoon, pulling hair and ears. There was testimony of an expert saying that there was also allegations of sexual abuse. There was testimony of an expert saying that the child told him that he had a secret that he could not tell anybody. The child was afraid of that, and the court still found that that was in grave risk of harm, even with an expert. Then we have, for example, Kufner versus Kufner, where the children came back from a visit with dad and started experiencing night terrors and eye twitching and nightmares. And they were evaluated, and the court determined that that was in grave risk of harm to the children. We have cases like Junan versus Junan, where grandma actually saw the dad molesting the child, where the child made an outcry, where there were 3 experts that testified that the child had been abused. But since they could not prove with a reasonable degree of medical certainty, it did not pass the test. And if we want to look at other cases, like cases from the 7th Circuit, we have a case, Altamirano versus Valles, where dad hit the child with an electric cord. That wasn't enough. Gil Leiva versus Leslie from the, I believe, the 8th Circuit. There was testimony that dad hit the child 10 times, leaving marks in the bare bottoms. That wasn't enough. In West versus Dobrev, in the same district, there was an expert affidavit saying that dad pulled the children's ears, they hit them with a belt, and spanked them. But the court found that because there was no evidence of the severity of the abuse, it was in grave risk. In fact, courts like the 2nd Circuit in Sorgotar versus Lee, the court said that isolated sporadic incidents of physical discipline do not rise to the level of grave risk of harm. These records fall short. Imagine this is the worst example they could come up with, was hitting a child with a foam slipper. That's the worst finding of fact about physical abuse in the record. Imagine all the cases that federal courts would receive. It will become the forum of choice for parents kidnapping their children and making their way to the United States in search of a friendlier forum. And for those reasons, this ruling should not stand, because it will wreak havoc in the convention precedent, because it will undermine our obligations under the treaty. Thank you, Your Honor. I will give my time for my rebuttal.
Ms. Harbour-Valdez. You need to unmute. We can't hear you.
I'm unmuted. I apologize. May it please the court. Good morning, Your Honors. Opposing counsel, Cori Harbour-Valdez on behalf of appellee Luis Enrique Reyes. As an initial matter, I do sincerely appreciate the accommodations of the court, which permit me to participate in this manner. I understand it's rare, and I am sincerely grateful for this opportunity. These cases are difficult. It's often troubling and almost always contradictory testimony that must be weighed by the district court, who is in the best position to observe the witnesses, weigh their credibility, and make these very, very difficult decisions. Mr. Reyes asks this court to give substantial deference to the factual findings and the credibility determinations made by the district court in this case. As this court has routinely held, a factual finding is not clearly erroneous as long as it's plausible in the light of the record as a whole, and these credibility determinations should not be disturbed unless a review of the evidence leaves you with a definite and firm conviction that a mistake has been made. Mr. Reyes submits that. Yes,
about the standard review. Let's assume that every factual finding the district court made as to what happened, what was shown in the record is true. Isn't it still a question of law as to whether that, given those facts, rises to a grave risk of danger?
Yes, sure.
So it's really a mixed question of fact and law.
It is a mixed question of fact and law, but we are asking that those factual findings be given the proper deference, especially where we've got some issues of credibility. I would like to address in response that I believe there is much more evidence in the record than just one spanking with a foam slipper. Ms. Garcia testified that she saw the appellant spank the children, hit the children whenever they would cry. The issue here is that we are dealing with two special needs, autistic, mostly nonverbal children. So for appellant to claim that there's no outcry, that there's no remarks by these children, that's disingenuous. We're dealing with children who don't have a voice, who can't make an outcry. So it is left to the adults around them to make these complaints, to observe their behavior and make these complaints for the children. Ms. Garcia was a neutral witness who very strongly testified that she had seen this abuse. She had text messages confirming this abuse, and it went beyond a foam slipper. The children were spanked on a regular basis. Miss Galaviz lost her patience. And frankly, I think she didn't know how to handle the children given their special needs. It sounds like it was an overwhelming situation at times, and her response was to discipline them.
Injured as a result of the spanking? What's the evidence about that?
I didn't hear
What were the children injured as a result of the spankings? What was the testimony about that?
I don't believe there's any evidence in the testimony about injuries. I don't recall seeing that, so I will concede that we may not have evidence as to injuries from those spankings.
Well, is that a problem? Is that a problem for your case then? Because As I understand it, this is not a traditional family law proceeding. This is a Hague proceeding where it's a very strong presumption that you have to overcome. And the standard is, not some sort of debate about parenting, but about grave risk of harm. Without evidence of injury, how can you prove grave risk of harm?
I don't think it's necessary to have the injury in this case. And again, I think that the difference in this case is the fact that we're dealing with autistic children. And that's a novel issue, a first time issue for this court, I believe. And the injuries are going to be different. Again.
But if your theory is that it's a different standard of parental care based on the special needs of the child, I'm certainly sympathetic as a personal matter. Why does that satisfy the grave risk of harm standard?
Because I believe it was established that Ms. Galaviz is incapable of caring for these children. The level of neglect and abuse demonstrated that they would suffer a grave risk if returned to her care.
Counsel, let me ask you about the text messages. When we say they're anonymous, what efforts were made? It seems like on a text you have at least a transmission number or something that might give a clue as to who's making, because this is important evidence. I think both sides agree this is important evidence, but to say that they're just somehow, they just fall out of the sky onto a phone device is a little bit of a stretch. Were there efforts made to locate who these people are and what the basis of these allegations would be?
Your Honor, I do not have an answer to that question. I unfortunately was not trial counsel, and I know the court doesn't like to hear that from appellate counsel, but in my review of the record, I did not see that any evidence to answer that question. I know that the trial court certainly considered that in the findings. I believe he said it was strong evidence of possible sexual abuse. But I don't have an answer for you on that, Your Honor, as to what efforts were undertaken to determine who in fact sent those messages.
I mean, you'd agree with me, though, that given the timing, it easily could be evidence that's contrived. In other words, evidence that was created after the fact from someone who is trying to assist in giving an edge in the dispute.
That is certainly a possibility, but it's also an equal possibility that it's someone who was alerting Mr. Reyes to the dangers that his children faced if returned to the care of their mother, especially if
But if I understand what you're saying, equally possible sounds like, there are sort of like a situation of equipoise, right? Evidentiary equipoise where competing inferences are available. Surely that's not enough to satisfy the Hague standard.
Well, I mean, I believe that the trial court reviewed the records from the hospital after the sexual assault complaint and exam. And
now, I get that there's deference to the trial record, but it's not absolute deference. We have to make sure that the trial court applied the proper legal standard to the facts. And just to be clear, I think what the district court said was it was a strong suggestion of sexual abuse, not evidence. And as I think you've already acknowledged, it's really just a matter of plausible inferences on both sides. I have trouble seeing that is enough to constitute a grave risk of harm.
And I think the way that the trial court coupled it with the evidence of abuse and neglect collectively with the strong suggestion of the sexual abuse, that constituted enough to constitute a grave risk should they be returned. I think he was taking everything as a whole. I don't know that he put his entire weight given on those suggestions of sexual abuse.
I have a question about timing. When did this abuse and neglect start?
I don't know that that's exactly known from the record. In reading it, I believe that it allegedly occurred when Ms. Galaviz would leave these children with this individual while she went to work in her salon. I don't know that we have a timing. From reviewing the records, though, and the indications on Grace, it had to have occurred, within the weeks prior to that exam. I mean, given the nature of the findings from the examining physician. But I don't believe the record establishes an exact time of when this abuse would have occurred. So I think another issue that I'd like just to briefly address is I understand that the courts in this country have never granted or denied a return on an Article 20 defense. Clearly, the court was troubled by the lack of education and the services being provided to these children in their most formative years. And I think one thing that this court could consider in removing the autistic children from this special education programming and therapies that they are currently receiving could also be considered under an Article 13B exception as a grave risk. If the children are returned to Mexico, their progress will clearly be disrupted, their development impaired, and I believe then this court could find that they would be placed at a grave risk of psychological harm under a 13B exception. The district court's finding that both children have experienced significant physical, psychological, educational, and verbal improvement that was well supported in the record. And the inability of Ms. Galaviz to be present with the children as required by the school in Mexico prevented them from attending school, thus depriving them of the programming and an education in Mexico. The Second Circuit has similarly held that this type of psychological harm pursuant to Article 13B, when it affirmed a petition, denial of a petition to return an autistic child to his father in Italy. That case, Armini versus Vittori, relied on the opinions of several international courts that made similar grave risk findings in refusing to return an autistic child to their country. So again, I think this is a very novel issue when you're dealing with the special needs of these children. And so should the court determine that the Article 20 defense was unsuccessful, Mr. Reyes would request that analysis be given in the framework of a 13B exception for grave risk. I know there was, appellant may argue that there was a report from Andrew's therapist which outlined some of the treatment that he had received, but it was clear from the record that both of these children had regressed upon the time of coming here with Mr. Reyes. They were both nonverbal. They had regressed to wearing diapers. In fact, Grace had not received any kind of therapies yet. And most importantly, the report by Andrew's therapist gave no opinion whatsoever on the effects of disrupting the current treatment that he's receiving here. So I think, if anything, there was some hearsay in there about other therapies that he had received, but it was clear that both of these children are now receiving the therapies that they need. And so returning them would be a grave risk under the 13B framework.
Where was the father living with the children in Mexico for a period of time?
Before the family separated, yes, Your Honor.
Why couldn't he return to Mexico and raise his children there?
He's a U.S. citizen and he has better job opportunities living in the United States. And there had been some discussion about the children being educated here. There's some evidence in the record that Ms. Galaviz had contemplated giving custody to a friend so that the children could be educated in the U.S. and receive Medicaid benefits here, and therefore obviously receive better therapies. And there was also some evidence that the parties had discussed Mr. Reyes having them attend school in the United States.
But those are all child custody matters that
They are, Your Honor.
Should be decided in Mexico, right?
I would agree with that, Your Honor. That all could be addressed. The issue here is the grave risk should they be returned. And I think that, again, given the special needs, given the the abuse, the neglect. I haven't even talked about the medical neglect, the poor hygiene, the condition that the children were in. I know there was some concern that Ms. Galaviz often left the children with her other children, or perhaps unsuitable individuals while she went to work. And that's just when you're dealing with children with these severe needs, it obviously caused the district court some concern. I also wanted to address the failure of the district court to consider the undertakings requested by Ms. Galaviz. I read the Golan decision to hold that a court, once it finds a grave risk, it can, but it's not obligated to consider whether there are any ways to reduce that risk so that the child can return home. The district court here heard evidence that Ms. Galaviz did not like being told how to handle her children or how to discipline them. That could certainly lead the district court to believe that she was not going to follow the court's orders related to proper care or an education of the children. The court also noted that Ms. Galaviz presented no evidence of suitable means of child care while she was at work. And finally, the district court expressed some frustration with the suggestion that it could issue orders directing the Mexican courts or Mexican entities to perform certain recommendations. The court noted that would be an exercise in futility to issue that type of order because he had no means of enforcing it. But should the court determine that the Golan decision requires that the court consider these undertakings, Mr. Reyes would request that this court remand it so that it can properly consider those undertakings. If the court has no more questions for me, our request today is that the district court's findings be affirmed, that Grace and Andrew be allowed to continue with their therapies and their education here in the United States, and that returning them to Mexico would in fact put them at a grave risk for both psychological and physical harm should they be returned to the care of Ms. Galaviz. Thank you, Your Honors.
Manzur?
What's your best case for when a court of appeals should reverse a district court's determination on grave risk of harm?
I think that Cuellar versus Joyce is pretty good. There are allegations about neglect, medical neglect. I think that Junan versus Junan from the First Circuit is good. Your Honor, there are plenty of. I can give you a case from.
You're clearly more fluent in these cases than I am. You're saying that those are situations where the district court made one finding, whether or not there was a grave risk, and the Court of Appeals disagreed and reversed. Okay.
Correct. That's the case. I would like to quickly dispose of the Article 20 defense. As we learned from the State Department, that defense only applies where the home country is against the fundamental principles that the requesting state guarantees. As we learned from San Antonio School District versus Rodriguez, education is not a fundamental right in the United States. But even if we say that it is, the record is completely devoid of any evidence, not on the trial court, not now, pointing at any deficiencies of the Mexican education system. Instead, is shifting the focus to the parent. And again, that's a more important focus or more relevant determination for a custody dispute. Now, Counsel is trying to bootstrap this allegation to all the other allegations. But Judge Engelhardt hit the nail in the head about the sexual assault allegation. We only had those text messages. The medical records were not introduced into evidence or admitted into evidence. There's absolutely no evidence, admissible evidence, saying that the abuse happened in Mexico. Those text messages were received, I think, 14, 15 days after the abuse by an anonymous source, and the text messages have no date. So as you mentioned, Judge Hall, it's an equally plausible explanation that the abuse happened in those 20 days that he had the children exclusively in the United States. Mr. Reyes could have given the proper care to these allegations if he had followed through with the same examination that he was referred to, but he didn't. So there's no evidence of sexual abuse. And as you pointed out, Your Honor, a strong suggestion is not clear and convincing evidence. And as this court pointed acknowledged in Madrigal versus Telles, a single big email from an anonymous source is not clear and convincing evidence of real risk of harm. Now, Judge Richman, you were talking about when these allegations of abuse happen. Well, it certainly happened at some point while his visitation and custody and possession suit was pending, and he did not make those allegations. He was separated from Ms. Gramillo for almost 2 years. The children lived exclusively with her. She was a primary caretaker. There was no police report in Mexico, no investigation of abuse and neglect, no claims for or requests for sole custody in Mexico at all. He came here to the United States because he knew that she could not follow. And now, another important thing to point out is that his witness said have not seen Ms. Gramillo and the children for over a year before the retention. So these allegations are a year old. And in her testimony, she points out twice that she informed him about these allegations a few weeks or a few months after that, while his suit was pending. This is forum shopping. And now, Ms. Harbour mentions Ermini versus Vitrolli. What's the difference there? That we have strong expert testimony. That there was testimony saying that the services in Mexico or the services in the other country were not available there. We don't have that here. This is a different case. Again, as you pointed out, there's no evidence of harm. There's no evidence of injury. And those findings about regression are pure speculation. There was no expert testimony, and as we learned from the Second Circuit and the Seventh Circuit, when the burden is clear and convincing evidence, inferences and speculations are not enough to prove clear and convincing evidence where there are other plausible explanations. And in this case, the other plausible explanations is that the abuse happened under his care, or that the children were afraid because for the first time in their life, they've been taken care of by strangers, and they were uprooted from the only environment they know. Your Honor, this court warned us about this in Soto. The court said that if we allow the automatic invocation of these exceptions, it will turn the convention into an arena of custody disputes.
Counsel, your time has expired. We have your argument.
Thank you very much.
That will conclude the arguments for the day. The court is recessed until 9 o'clock in the morning. Thank you.